Hi, everyone. Welcome to this week's bonus immigration attorney live chat here at Immigration for Couples. I'm attorney Megan Pastrana, and my firm, Immigration for Couples, is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. So I'm hosting this bonus session. I usually host these live chats on Tuesday mornings at 11 a.m. Eastern Time. And I've had so many people joining live, and we've had more questions than I'm able to answer in that time. And I've also had a lot of individuals ask, can you do this in the evening because of work? I know a lot of people were trying to take lunch breaks and things like that so we could all be together and I could answer your questions. And so I decided to host this bonus session here this week, an extra session to go over any questions that you all have. I actually do have some individuals that sadly couldn't join us. And so someone had asked a question in the comments before the show. So I will go over that question as well from, I believe it was Mickey is the name. But before we dive into questions, I want to let all of you know about the free resource center that we have on our website at immigrationforcouples.com. And I'll post the link in the comments after the show as well. But the free resource center was created by my team and myself because we know that knowledge is power in your immigration journey and that the immigration process, it's a labyrinth. And we put a lot of love and care and consideration into creating this resource center for all of you. And just to kind of give you an overview of what the resource center includes, I have a free relationship evidence guide that you can download. And that relationship evidence guide is very thorough and really goes into what immigration is looking for in terms of determining whether or not they believe you have a real love. And I also created a webinar that it's not like your typical webinar. It is a webinar that's going to go over the options that are available to you as a couple. It's really great if you're just starting out in your journey to understand your options, understand your next steps, and understand how to not just survive the immigration process, but thrive. So all of those resources are free to you on the website, immigrationforcouples.com. All right. And I am streaming live on Facebook, LinkedIn, YouTube, and Instagram. And so I see we have some individuals joining on Instagram. If you want to throw your questions in the comments, I will answer them in the order I receive them. Instagram is the only one I have to toggle over to a different screen, but I will keep an eye on that as well. So the first question I had was from, as I said, Mickey asking about the National Visa Center process for the spouse visa. And the question I received is, basically, if we have our I-130 petition pending, so that's the very first step of the spouse visa, are we able to pay the National Visa Center fees, which is the next step in the process, and start working ahead? So you can't pay the National Visa Center fees until you receive a welcome email or a case creation notice. So I love the proaction. I love that you're wanting to work ahead. We're all about that here at Immigration for Couples. We're always working ahead for the couples that we represent. But unfortunately, that you have to wait to pay those fees until you receive that welcome email. But you can start to collect the documents that will be needed for that phase, like tax returns. The affidavit of support is a big piece. And the other question that was asked is, there's a choice of agent option on the NVC portal. And so if you have an immigration attorney that helped you with filing your petition, here at our office, when we file for clients, we're automatically added to that portal. So you wouldn't have to take any additional steps. So that registered agent, it's a little different than having an attorney, but this person was basically asking, do we need to do anything with that? And so if you have an immigration attorney, he or she would be registering their appearance in that portal, or if they were with you since the beginning, it will already be in there. So all right. And then, oh yes, Lisa, Lisa, you're always, and Terry, we have a lot of regulars that are here with us on Tuesday mornings. So I love that you're here with me in the evening too, on a Thursday. So happy Thursday. Let me know, where are you at in the world? I forgot to ask that question. I love asking where is everybody at? If you're in the United States, city and state, if you're, what city and country are you in if you're outside of the US? All righty. So next question is, after 3.5 years of waiting, My American son and his wife finally have their I-130 approved. Yay! Congratulations. That's super exciting. 3.5 years. That's a brutal wait. That's long. And you're wanting to know about how long it takes to get an interview in Brazil. So we have a lot of clients in Brazil. And on average, once you've completed the National Visa Center phase of the process and you are in the queue, documentarily qualified, typically we see interviews being scheduled within about 6 months, give or take. We've had some come in sooner, maybe take a little longer, but on average, that's what you'll be looking at. So best of luck. I hope you get an interview soon. Like I said, 3.5 years, it's a long wait. So hopefully you can all be reunited very soon. But congratulations on the approval of the petition. And good evening, Lisa. Great to have you with us. Terry, good to see you again as well. Yeah, and it's evening here where I'm at, but it's morning for you in the Philippines. Thanks for being with us. And yeah, good evening from Nigeria. All right. So now, okay. Let me see who's next in my queue. I have so many questions that are coming in. It's a little bit of a flurry. So can I use joint sponsors income for the I-134 regarding the fiance visa because my original petitioner's income is not enough? Okay. So great question. For those of you who are just starting out or maybe you're not doing the fiance visa and so this isn't applicable, to give you a little bit of context, when you're going through the fiance visa process and you get to the interview phase, one of the requirements is a type of affidavit of support. So there's an I-864 affidavit of support that happens later for the green card. And then there's a step even before that called the I-134. I like to call that the half-affidavit because it's like a half version of the I-864. And so the I-134 is very similar in terms of requirements to the affidavit of support. And so in order to receive a green card, you as the United States citizen or lawful permanent resident petitioner, for fiance visas, you have to be a US citizen. But in order to petition for your fiance or spouse to have a green card, ultimately, you have to show that the immigrant beneficiary will not become what's called a public charge, will not need public assistance. And so you do that through an immigration form and providing your financial documents, like your taxes. If you as the petitioner don't make enough based on poverty guidelines to be the sole sponsor, then you can use your assets. So if you have a home or financial accounts, that's a possibility. If you are using assets, it has to be more than the poverty guidelines, 3 times more. Alternatively, you can have a joint sponsor. So yes, if your petitioner's income is not high enough, then you do need to be looking at assets or a joint sponsor. So that is correct. All right. It's great to see you here with us again, Olive. I know you've asked questions about your case and the status of your case, and you've been waiting on immigration, I know, for a while. When immigration will contact you will depend. I know based on comments that you've left on prior lives that you're getting really close. So based on your timelines, I would anticipate very soon. I know one of the members on our team, one of our paralegals, she's amazing. I love her. I love working with her, Catherine. She says sometimes it's at the point when you feel like you can't wait any longer that the decision will come through. So hopefully very, very soon, sending you prayers and positive vibes that decision comes very soon. All right, let me check here on Instagram. I do have some individuals who are watching live. So it's great to have all of you here. Okay, so I have a question. I can't, because it's on Insta, I can't pull it up on the screen, but I'll tell you that this question is an individual who's asking, how long does the spouse visa take right now? And how long does the fiance visa process take these days in San Francisco? So the wait times for spouse and fiance visa aren't really going to be determined by your state. The very first step of the process is a petition for both the spouse and the fiance visa process. And that wait time for this, on average, I'll say for the spouse visa, the wait time for the very first step, the petition, is about 12 months, give or take. The fiance visa was really tracking about the same wait time, but then in recent months, we've seen the wait time go down, and we've seen individuals getting decisions on the very first step, the petition, in around 6 to 8 months. From there, both case types will go through a National Visa Center process and an interview. Um, it the ultimate wait time for both the spouse and fiance has a lot to do with the immigrant beneficiary's country of origin. Some countries have a very long backlog, and it takes much longer to receive an interview. I'm thinking countries like in Mexico, Ciudad Juarez, they have a very long wait. Lagos in Nigeria, they have a very long wait. It can take more than 2 years to get through the spouse visa process. But on average, to get from beginning to the end of that spouse visa process is about 18 months. It can be less or it can be much more depending on the specifics of your case and also that country. For the fiance visa, earlier in the year, it was about 18 months for both processes, but now we're seeing with the fiance visa that it's closer to about a year from beginning to actually receiving that visa. Understand again, the fiance visa, just like the spouse visa, is going to be very fact specific or based on the specific facts of your case and also country. So, if you had a fiance visa case and you're processing through the embassy in London, you would likely get a decision on your case in under a year. But if you're looking at someone who's processing through Rwanda, for example, you're looking at well over a year. So I know that that's a lot of different numbers that I'm throwing out there, but I think you can understand, or you're understanding, I'm sure, with what I'm saying, is that wait times just really vary. But on average, about 18 months for the spouse visa, 12 months for the fiance visa. And it'll just be less or more, give or take certain factors. All right. But great question. I know a lot of people want to know wait times, which makes sense. You want to know when are you going to be able to be together, right? All right. Let me see here. And for those of you who've just joined us, welcome. It's great to have you. I'm streaming live on Facebook, Instagram, LinkedIn, and YouTube. If you have questions, throw them in the comments, and I will do my best to get through as many questions as I can here with you this evening. All righty. Who is next in the queue? And also, please let me know, where are you at in the world? All right. Okay, so Terry, you're asking about interview and what your husband will be expected to take with him as far as evidence. Okay, and then you had a separate question. So the interview and what you need to take, you'll all hear me say this a lot. It depends. And it depends on your case. It depends on the country. It depends on your background. And so I think you had asked this question on Tuesday as well, or a similar question. And so if it's a case that's going to happen in a U.S. embassy or consulate, you need to check the specific requirements of that particular embassy or consulate. And some countries have different requirements. Some have you take 2 passport photos. Others have you take 1 or 8. So looking at the embassy specific guidelines. And then birth certificate is always something that's going to be required. Any versions of the passport, like current and prior passports, is always going to be a requirement. Background checks, police background checks from any country that you've lived in for more than 6 months. And please know, these are just some examples, but there's so many more documents that you'll have to take depending on your specific case. If you have so you'll have to take your affidavit of support and tax returns, updated tax returns, depending on how long you have been, waiting for your interview. If you have a joint sponsor, all of their financial documents as well. But definitely start by checking with the specific instructions for that U.S. embassy or consulate. And if it's an adjustment of status interview, for example, in the United States, that would have a completely different list of evidence. Typically, you're not required to bring a police background check. But for all couple-based cases, bringing updated relationship evidence is very important. So you definitely want to do that. All right, but great question. And then you are wanting to know too, if it takes longer for a visa approval if you have a joint sponsor. Sometimes it can. It's not going to necessarily automatically delay the case because you have a joint sponsor, but if immigration looks at your joint sponsor application and determines that they want to see other evidence, they could request that, and that could potentially cause a delay. But in general, having a joint sponsor wouldn't impact the wait time too significantly. Oh, that's very nice of you. I'm definitely feeling much better, and I appreciate you saying that. So thank you very much. All right. So, and your question is, if you want to change your last name, if you want to shorten it, can I do this during the K-1 fiance visa process? All right. So after you receive the fiance visa and you come to the United States and you get married, then you'll be getting married, and then you'll be filing your green card application. So in the United States, when you get married, your marriage certificate is an official name change document. So you're able to change your last name. So if you have two last names and you want to take your spouse's last name, for example, or do a hyphenated last name, you can definitely do that. If you're just wanting to just change your last name, and just have one instead of two last names, typically you can't do that. It would have to either be you're taking your spouse's last name or you're doing like a hyphenated last name. And sometimes what individuals, it depends on your state. So name change rules are really interesting because they have a state specific component. And so some states will let you take one of your last names. So if you have two last names, or just if you have one last name, take your last name and move it to your middle name. And then you could take your spouse's last name. So I know this is complex, and it will depend on on your state. So you would look at state specific name change rules, and then after the marriage, though, on your green card application, you can indicate how you want your last name to appear, and then your social security card then and green card would be issued with that last name. Something else to think about too is what a lot of individuals will do is, after you have your green card, if you received your green card based on marriage to a US citizen, you can potentially apply for US citizenship 3 years after you've received your green card, or the 3-year anniversary of your green card issuance date. And when you apply for naturalization, you can make any changes that you want to your name. If you wanted to change your first name or change your whole name, that can actually be done as part of the naturalization process free of charge, because they would actually do your oath ceremony at a federal court, and you would get your naturalization certificate, and then you'd get an official legal name change document. So it could also be done at the naturalization phase as well. So I hope that makes sense. But yeah, name changes can definitely happen at the green card phase after you're married. All right. Okay, yeah, and then on Instagram, Callie is saying that we have 100% legitimate 5-year relationship with photos, trips, and other evidence. That is awesome. That is a solid foundation to begin either the fiance or spouse visa process. So that's great. All right. Let's see who is next here. Okay. So you are looking to get married before the end of the year, and we were thinking of applying for the spousal visa soon after that. Any issues? Okay, and we live near each other. Okay, so you're in Canada and the United States. So that's great. That's great that you're getting married. So congratulations. That's very exciting. So any issues? Well, I would need a lot more information from both of you to give you a full 100% legal advice on if I see any possible potential issues with your case. If you're asking, is it okay to file your spouse visa application shortly after marriage? Yes, it's possible. We do that all the time for clients. Understanding Oh, here, you said, okay, here, you had another part to it. So you want to understand before we do something that could potentially harm the visa application. Yes, that is exciting. Instead of driving back and forth, to be able to be together sooner rather than later. That is very exciting. And it's exciting that you're getting to do some wedding planning and that's happening this year. So it's definitely possible to file your spouse visa application shortly after the marriage. Just remembering that in your application, it's your burden to prove that you have a real relationship. Immigration has a very long list of red flags that they look at in determining whether or not they think a relationship is legitimate or real. One of the red flags is filing an application shortly after marriage. That doesn't mean that they're definitely going to deny your case, but it's just something to be aware of, that you want to make sure that the application that you file is solid and shows, your relationship history, the longevity, and I would really encourage you check out the free resource on my website, immigrationforcouples.com, that's in the link below. Check out the relationship evidence guide and check out the webinar, so you can understand more about what immigration is looking for. But yes, it's definitely possible to do. Just making sure you have a really strong case with your relationship evidence. In terms of your question of, are there any other issues with your case? I'd be happy to speak with you both on a consultation. You can call the office or schedule on the website, and we can jump on a Zoom call and talk about the specifics of your case and make sure everything is in order before filing. And definitely, if you haven't spoken with an immigration attorney and this goes for all of you, before you get married, that's a really, really a great time to speak with an immigration attorney, because sometimes you might have options that are better. Like the fiance visa might be better for you because of wait times or because of any given factors. Sometimes there are special options for filing directly with an embassy or consulate. There could be options that are available to you before you get married, that definitely you want to make sure you understand all of those options. You still can have options after marriage, but it always breaks my heart when I get on a call with couples and they say, "Oh, I wish I would have known." So a good time to have that conversation is before getting married. So I wanted to throw that out there. I'd be remiss for not sharing that. Yeah, and Rudy, you're asking about the petition for the fiance visa. Definitely, I encourage you to check out that free resource on my website, immigrationforcouples.com, about relationship evidence, because it is it, it there's no set amount of photos, for example. There's no set amount of pieces of evidence. It's going to be really specific to your story and your relationship of love. You're telling immigration your love story. So in depth, yes, immigration wants to see different types of evidence. They want to see how long you've been in a relationship, what connects you both, what are shared activities, be it trips that you've taken. Do you have shared finances yet? Letters of support from family and friends. It is pretty in depth. The immigration process, by its very nature and what you're having to prove, is a bit invasive. But if you look at it like a lot of our couples do, we're kind of like putting together memories with each step in the application process. And it's nice to go back, even though the immigration process can be stressful. It's nice to go back and look at the applications. It's a moment in time of your life, of your shared time in that moment of time with each step. So you're collecting evidence of your love story. All right. Yeah, you're wanting to know how long it takes to get an interview in Nigeria. For most of our clients, at least a year for the spouse visa. For the fiance visa, a little bit less if the calendar will cooperate and dates are available. But on average, you're looking at least a year. That's what we're seeing for our clients. All right, June, it's great to have you with us. Your husband is a U.S. citizen and will be petitioning for you for your green card. However, you're both students now. You don't have income currently, and you can't find a qualified joint sponsor. Okay. Can we use savings as financial support? Our combined assets exceed 5 times of the 125% poverty guideline. So assets is a great thing to look at if you don't currently qualify on the petitioner doesn't currently qualify on income alone. So that's usually what we look at for our clients is if you don't make enough yet, your students, you're in your early phases of life, looking at assets is a great option. And with assets, immigration wants to see 12 months of those assets if it's a financial account. And they take an average, a rolling 12-month average. And they want to see 3 times the poverty guideline. So if you have 5 times, that's great. It is possible to use both of your income. It's going to depend on the consular officer because sometimes they will not want to consider the immigrant beneficiary's income. They really want to see that the petitioner spouse has that amount of assets or the required income alone. But it's definitely something that is a possibility for sure. If you can't find a joint sponsor, do keep looking for a joint sponsor, remembering a joint sponsor can be anyone, family or friend who is a lawful permanent resident or U.S. citizen. I know it's a big ask, but keep asking because it's always good to have a backup plan with immigration, but assets is a good place to start. And I'm definitely, as always, for all of you, so June, that goes for you too. You're welcome to schedule a consultation with me and we can go over your specific assets and information in detail in private, and I can give you more customized guidance if you would like. Okay, so I have time for a couple more questions. The time is flying by here, and everybody has fantastic questions, and I love seeing everyone here. On Instagram, it looks like I might have another question. Okay. So I had someone on Instagram that's saying thank you so much for the videos. You're very welcome. And wanting to know about adjustment of status and waiting to file. So I'm not sure I understand fully your question, but I will give you some information. Oh, yeah. Okay. I just wanted to see because I have a couple screens here and I'm looking at a lot of different things. So for adjustment of status, um, there's a lot of rumors out there, a lot of things online, right, that say, oh, if you come on a tourist visa, if your fiance comes on a tourist visa and you get married, then you can file the adjustment of status as long as you wait 90 days. But that's not true. Immigration says the immigration laws say that a tourist visa is for non-immigrant intent, which means you can't come to the United States with the intent to live. So it is your burden to prove that's not your intent. So if you were to do that, so it breaks my heart when I see couples who have read that online and then try that, and then they get scheduled for an immigration interview, and the officer says, "Hey, it looks like you came here on a tourist visa, got married shortly after, and that this was your intent in coming." And then they are confronted with having to file a waiver of forgiveness for doing something that's not allowed under immigration law. Is it possible that someone may come on a tourist visa and while they're here visiting, fall in love with someone, or sometimes individuals come on a tourist visa and for whatever reason ultimately overstay that visa and later fall in love? If it wasn't your intent in entering the United States to stay here and get married, it is possible. But it's very, very, very fact specific. It's a very nuanced. All of immigration law is nuanced and complex. And so you definitely want to talk with an immigration attorney to understand if filing adjustment of status is possible for you if you're eligible. So I will say that on adjustment of status. Everybody wants to do adjustment of status. I understand because you want to be able to be together as soon as possible and not have these prolonged wait times. But you have to be careful because obviously your goal is to be together and not have to have issues in your immigration case. So, okay. Oh, okay. And so you were saying that you're hoping that one of these trips that your fiance would stay here. So again, everything I've said about adjustment of status, you just have to be very careful. You might consider looking at getting started with the fiance visa process if you've both been, visiting one another, and you're ready to start your lives together. That would be the next step. So I encourage you to check out the webinar on my website. In the webinar, I go over the different options that are available to you as a couple. So, all right. And I have some more questions here in the queue. I'll try to do a couple more here. Okay. So it's great to see you. It's been a while. I think you've been on some lives previously. So good to see you again. So you say that you're divorced and you have a 10-year green card. When can you apply for citizenship? So again, this is why I created the resource center. I will answer your question, but I really encourage you check out the resource center that on my website, immigrationforcouples.com. And I have a bunch of videos about the naturalization process and a free downloadable resource on the steps involved in the naturalization process. So the naturalization process is what takes you from green card to U.S. citizenship, your U.S. passport. And if you have been married to a United States citizen and you're still married and living with your U.S. citizen spouse, you're able to file typically at the 3-year mark. Some individuals might not be eligible for various reasons, but in general, 3 years. For everyone else, you have to wait 5 years before you can file for citizenship. So based on what you're saying, it sounds like you'd fall into that camp of the 5 years. But again, check out the naturalization section on my website and that free resource center to learn more about the naturalization process. But great question. Oh, this is a good question. All of them are good questions. So if you have a planned engagement, can I get a head start and start preparing the paperwork? So by the time I'm engaged, I could just fly right away for file right away for the fiance visa. So here at Immigration for Couples, we love proaction and working ahead. We're always doing that for our clients, as I said earlier. And so definitely, you can work ahead and get things ready. And so as long as you meet the requirements for the fiance visa, and you're legally free to marry, you've met in the past 2 years, and meet all of the other requirements, then getting things ready to file is perfectly fine. If you haven't met in person yet, and that's the step that you're needing to complete, that's what we do all the time for our couples, getting things ready. And then once you meet that final requirement, getting it filed. So that's great, but you can't file until all of the requirements are met. All right. So have I found that applications from the UK, as well as those who've worked in the US on an F1 are on average faster to receive their visas? That's not really a factor that I've seen as making the case faster for a spouse or a fiance visa, having worked or studied. It's helpful if you have, that prior immigration history of compliance with immigration rules, but it wouldn't necessarily be a factor and making the case go faster. I will say that our clients from the United Kingdom, typically out of really all the countries in the world, it's one of the faster embassies in terms of interview scheduling. But the petition phase, the very first step, that's adjudicated, it's decided in the United States. So that's not country specific for the first step, and that's the longest part of the wait. But interviews definitely are scheduled faster for my clients in the United Kingdom. So okay, you're very welcome for the response. Yeah, I empathize with you. I went through an immigration process with my husband years and years ago. We did have a long process, not 3.5 years, but I totally get it. And it's really my journey is what propelled me into being a guide to all of you. So, and a lot of people on my team members have also gone through their own personal immigration journeys. So we get it. And I'm really excited for you and hope we get an interview very soon and be together. So Lisa, you are wanting to know about waiver for vaccines. My son's girlfriend is in Northern Ireland. So yeah, I know you've had questions about the vaccine waiver. So yes, unfortunately, it does make the process longer. Waiver applications currently waiver applications are well over 2-year waits. Sometimes the vaccine waivers will be adjudicated faster. And for all my clients who apply for a vaccine waiver, we do an expedite request because it's insanity to be waiting 2 years on a waiver. But the short answer is yes, it does make it longer, unfortunately. All right. Am I finding that Canada is one of the countries that is a little bit faster with fiance visa approvals? During the pandemic, the embassy in Canada really slowed down a lot, and it's taken them a while, but they are starting to catch up. They are still a bit slow with spouse visa scheduling. Fiance visas, we get to schedule that interview. Typically, part of the battle with fiance visa cases is, yes, you can schedule your own interview, but getting in and having there be actual interview spaces available. But yes, typically Canada is one where you can get a fiance visa interview a little faster than, say, Lagos, Nigeria, for example. That's much longer. Okay. So, oops, I'm sorry. Let's see here. So how much age difference is enough difference? Does 40-year age gap justify for the fiance visa? So as I had said earlier in our show here, the immigration has a really long list of red flags that they look at in determining whether or not a relationship is bona fide. Or in other words, it's based on love and not just to receive an immigration benefit. Age gap is one of those. In general, immigration is concerned with any age gap that's really greater than 10 years. Understanding that that's just general guidance and it's discretionary. So we've definitely helped individuals with similar age gaps to what you're saying here, a 40-year age gap. And it's going to come down to showing immigration that your particular love story and why this relationship is real and that the age doesn't matter. So it is something where it's a little bit more of an uphill battle. It's an additional hoop that you're going to have to jump through to prove your relationship. But, and it's definitely something immigration will look at. All right, let's see who I have next here in the queue. Oh, okay. This is can you advise which has a higher success rate, fiance or spouse visa? I have been denied a student visa twice for lack of home ties, and I'm worried my fiance visa might be rejected. Yeah, so that's a popular and it's an interesting question, which has a higher success rate. So I think there's this rumor out there that a spouse visa is more likely to get approved than a fiance visa because you show more of a commitment if you're married. But the reality is that for both the fiance and the spouse visa, the standard is a bona fide relationship or bona fide marriage. The standard for the case for the relationship is really going to be the same. So I would say in general, the success rate is really, really the same for both. It just comes down to which path makes the most sense for both of you. A lot of individuals right now would choose the fiance visa over the spouse visa because in general, it's been faster to be able to be together. For others, they might opt to not do the fiance visa because the immigrant beneficiary needs to work right away. Sometimes the fiance visa might not make sense if the petitioner has certain criminal history, for example. So which will have a better success rate? Really, they're pretty similar. It's going to be a matter of which is the better path, which is more in alignment for both of you for your particular goals and your relationship in your particular situation. All right, I'm going to do one more question. I have so many questions here that are really great, and I wish I could get to all of them. All right, let's see who's next in the queue. Thanks for your super helpful chats. You're very welcome. My pleasure. Your questions about reopening of approved I-129 cases. Our case was approved first, but then reopened for reconsideration. Yeah. So if your petition, a spouse or fiance, even if USCIS approves it, your interview that you're going to have at the US Embassy or consulate is super important because that immigration officer is getting a final decision on your case. They can actually tell USCIS that they made a mistake and that they don't believe the relationship is real. So it's really important to know. They can send your case back to USCIS for reconsideration if they don't believe the relationship is real. Or there could be other issues in terms of eligibility. Sometimes people think that their divorce was finalized previously and it wasn't. And if that divorce wasn't finalized, your petition can't be approved. There can be many, many, many different reasons of why the case would be sent back. Immigration would be sending you, or USCIS would be looking at whatever the immigration officer at that embassy or consular interview said, and then they will be sending you a notice of intent to deny, a notice of intent to revoke, and will outline the reasons for this reconsideration, giving you an opportunity to respond. So it could be a lot of different reasons. If you haven't received that yet, it should be coming in the coming months. Definitely, if you don't already have an immigration attorney, you need one. And once that's received, I would be happy to speak with you one-on-one in a consultation and go over options and next steps. Okay. I know I said one more. It's really hard for me to not answer all of these questions, but I do need to. It's almost 7:00 here, and I'm getting hungry. Let me do one more. Okay. Okay. Is it possible for my Canadian spouse to travel to the US while we wait for the I-130? I don't see any clear information, but people tell us to be cautious. The case was just approved and moved to the National Visa Center. So I've made videos on this topic because, like a lot of things in immigration, there's a lot of rumors out there and a lot of conflicting or inaccurate information. But if you have a pending spouse visa case or a pending fiance visa case, and you already have a tourist visa or ESTA, or if you're from Canada, you can travel to the United States while those applications are pending. But you have to understand that every entry is discretionary, and that immigration officer is going to be asking you questions because they want to make sure that you don't have intentions of coming here and staying. And so sometimes what will happen is immigration sees that you have this pending spouse or fiance visa application, and you have that's an intention to come and live in the United States. And they could decide to say, hey, we're not going to let you in. You're going to have to go back and you have to wait for your interview. And then when you receive your approval on your visa, you can come. So it's possible. It's possible to travel. Just know that you need to only come for a short visit. You have to convince immigration that it's just for a short visit, and then you will be leaving. Ties to your home country, like a job that's requiring you to report back and things like that, would be helpful to bring with you. And of course, answering, the immigration agent's questions honestly upon entry, but understanding they could deny you entry. All right. I'm looking through these questions. Oh, this is a good question, Clarissa. You always forget to ask on these chats if you wanted to bring your mother-in-law on a tourist visa, is that difficult to do? So, in what kind of tourist visa would that be? You want to show what Florida has to offer. Florida has a lot to offer. I like being in Florida. So a tourist visa, yeah, there's one kind of tourist visas. Tourist visas are difficult to obtain. The reason being is that immigration kind of starts every tourist visa application or interview with the belief that everyone just wants to come and stay and live here in the United States. But the reality is that some people just want to come and visit and go to Disney World and go back home. But immigration starts every application and interview kind of with that mindset. So it's a bit of an uphill battle to get a tourist visa approved. Similar to the question that I was asked here about coming and visiting the United States on a tourist visa while an application is pending, it's your burden to show that the visit is short term. So the more you can show that a person has ties to their country of origin, home ownership, a job, financial like assets, if they have, money in the bank and things like that, that is in their country of origin and that they can financially support themselves for the trip. When you have a family member that's coming, like your mother-in-law, you can always do a letter of support that she can carry with her, that you explain that I want her to come for XYZ reasons. It's going to be a short visit and that she will go home, and providing, your financial documents and something called an I-134 form. So another big piece of the tourist visa battle is that a lot of times individuals will go to their tourist visa interview and the immigration officer will unfortunately refuse to look at any of the documents, and they'll just say, we're denying you. And sadly, the reality is that immigration officers legally are allowed to do that because tourist visas are discretionary. So I'm sorry to rain on your parade about tourist visas, but I do want to give you the reality. That doesn't mean you can't try, but I always want to give everyone realistic expectations and understandings of the system. People do get approved for tourist visas, but sometimes it's kind of like playing the lottery. All right. Glad you were able to attend to Eds. It's been a while. I know you have a lot going on right now in your life, with the updates that you've given us on prior lives. So you're very welcome. You are very welcome. Hi, Anna. It's so great to see you. I hope you're doing well. All right. I know the OMG is for the wait time on the waiver. I'm just getting caught up on all the I know that can be part of whenever I know you said when they're ready that you were going to reach out to us. So we're here whenever, but wanting to family planning and wanting to start a family, that can be part of our expedite to get that waiver pushed through for them. All right. You're very welcome, Pooja. It's great to have you. Good. You're welcome, Rudy. I'm glad that helped answer your question. All right. All right, everyone. I do need to jet. I think we got through a lot of questions tonight. If you enjoyed tonight's session, if you give me a thumbs up or a heart, I'd appreciate it. Share this with anybody you know who's going through the immigration process. Invite them to come to a future live, or share the resource center. It's a free resource center, so check it out. All right, everybody. Have a wonderful rest of your week and a fantastic weekend. And I will see you all next Tuesday at 11 a.m. Eastern time. All right. Take care, everyone. Bye.